Thank you everyone on this session, all the participants who have joined today to hear on this topic, which we would try and make it more practical and experience sharing than just theoretical. And thanks, Nick, to join this session with us. I know it's been as bad as in India as in London for you. It's not easy times for all of us, but thanks again for spending some time with us and giving your valuable inputs on this topic. So we'll come to you in a minute, uh, discussing some of the international experience that you already have. But before that, just for the basics, let me first invite Shweta to give a little bit of a perspective on enforcement of both foreign and domestic awards in India. Particularly, we all know seat plays a very important role in arbitration. While the arbitration is ongoing, when you need interim reliefs, when you need to approach courts for assistance during arbitration. But does that have any effect on enforcement of an award? Shweta, if you can give us a little perspective on that.
Thank you, Vyapak. So seat plays a very important role even at the stage of enforcement, because depending on where you've received your award, depending on whether the seat is in a reciprocating country or a non-reciprocating country, the entire procedure for enforcement would be applicable. Like, for example, India has notified about 50 countries as reciprocating territories. So in case of these 50 countries, the awards would be directly enforceable under the Arbitration Act, which is similar to New York Convention, at least Part 2 of the Indian Arbitration Act. However, in case of a non-reciprocating country, you have to file a fresh suit and the Part 2 of the Indian Arbitration Act would not apply. So seat plays a very important role in enforcement as well.
Sure. So I think the point that we are trying to address here is in terms of any foreign award, uh, typically, New York Convention would govern the enforcement, while everyone would think that so long as any country is part of New York Convention, enforcement is easy. But in India, there is a little bit of a nuance, and you need to see whether that country, which is part of New York Convention, is also notified as a reciprocal country. And there are about 49, 50 such countries out of 160 odd countries which have notified or agreed to the New York Convention for enforcement of award. So far as enforcement of domestic award is concerned, I think Part 1 of the Arbitration Act would govern, subject to 42, as to where the assets lie and where you can file for the enforcement or the execution of the domestic award. So, with that introduction, uh, any other specific points, Shweta, that one needs to take into account, particularly for a foreign award? As we know, there is a two-stage process, if I may not say, two different processes. It may be one process, but in two stages. One is recognition and then the enforcement slash execution. So are there any specific points that one need to take into account, including the recent legal jurisprudence on Limitation Act, that you may want to, apprise the participants today?
Indeed, Vyapak. So typically enforcement proceedings in India, like you've mentioned, is a two-step process. First, it has to be recognized as enforceable in India, and once it is recognized as enforceable in India, it would be executed as any decree of an Indian court. Now that is where the Indian law comes into picture as to how the execution will happen, which is under CPC, which we will be discussing in the course of the session today. Now, although it is a two-step process, when we are filing a petition in an Indian court for enforcing a foreign award, it will be one petition, so you don't have to really file two different petitions, one for recognition, one for enforcement. So execution petition suffices over here. And now where to file this petition? That would be ideally where the assets or the property of the opposite party are. Accordingly, you can file your enforcement petition. If you're not aware of where the property or the assets are, you can of course go for asset tracing, etc. and locate the properties. If this is not possible, then you can also file where the registered address of the opposite party is in India. Now, coming to limitation, a series of High Court judgments have come into place recently, the Bombay High Court, Delhi High Court, as well as the Madras High Court. And they have, on these lines, told because a foreign award is stamped as a decree when it's coming to India. Although there is a two-step process, it doesn't really undergo a different procedure for being enforceable as a decree. Since it's being stamped as a decree when it's coming to India, the limitation period which is applicable to decrees as such in India would be applicable to foreign awards as well, which is 12 years. Now, Bhavana would be discussing this in further detail. So, over to you, Vyapak.
Sure. Sure. I think that's very important, and there are two different judgments recently, one from Delhi High Court and one from Supreme Court, concerning the limitation period, one for enforcement of award and second for enforcement of judgment. There may be some overlap as we go along, but Bhavna would deal with that a little bit in detail as we go further on this issue. So let me straight away bring Bhavna on this. Bhavna, if you can also talk a little bit more about the mandatory requirements for enforcement in India and also elaborate on this judgment because it's an important judgment for people to know when their right goes away, even if they are holding a foreign award in their hands.
So thanks, Vyapak. On the mandatory requirements that an award holder would have to satisfy, the award holder would have to have certain documents such as a copy of the award itself, a copy of the arbitration agreement or a certified copy, other evidence, and if, for instance, if the award is in a foreign language, a translation of that into English. So these are certain requirements that you would require to have before filing your enforcement petition. Now, another important requirement, as you mentioned, Vyapak, is that of limitation, and the award holders need to be apprised of the current situation in India. So, for foreign arbitral awards, particularly, there were differing views across different high courts on whether there would be a limitation period of 3 years applicable or a limitation period of 12 years. Recently, the Delhi High Court, in a judgment in India, has held that the limitation period would be 12 years. Now, the rationale Shweta has explained is that the Foreign Arbitral Award is considered a decree, and a decree under the Limitation Act has a limitation period of 12 years. However, at this point, I should also mention another judgment of the Supreme Court that has come out very recently in the case of Bank of Baroda. In this case, it does not pertain to a foreign arbitral award, but it pertains to a foreign decree. In this case, among other things, the Supreme Court has held that the limitation period for a foreign decree would have to be determined on the basis of the country's limitation law in which the decree itself was issued. So, as you can understand, these two judgments for a foreign decree and foreign arbitral award were almost close together in time. So, neither of them had referred to the other. So, at this point, it's also possible that the Supreme Court, relying upon this judgment of the Supreme Court on foreign decrees, may take a differing view on foreign arbitral awards as well. So, as of now, the Delhi High Court has held that it's a 12-year limitation period, but we should be cautious going forward and potentially try to apply for enforcement within a period of 3 years, as there is a possibility that the law may change in the future.
Sure. So I think everyone, when they go into an arbitration, goes with a very, positive thought process that, look, this is award is like a finality. The moment I get the award, that's it. I get my, dues, monies, whatever is awarded under the arbitration proceedings or whatever the other claims were. But in your experience, in spite of having a foreign award or in that case, even a domestic award, what are the common set of objections that you have seen challenging the recognition? And where does the legal jurisprudence in India, at least in that aspect, is prevalent as of now?
Thanks, Vyapak. So, the objections to an arbitral award, a foreign arbitral award in India, can be raised under Section 48 of the Arbitration Act, which is modeled around Article 5 of the New York Convention. So there are a number of objections over there, but I'll deal with the ones that we commonly see in practice. While there are objections dealing with a party not being able to present its case or the award being beyond the scope of submissions, the large number of objections that we see are actually on the grounds of public policy. So now public policy in India has actually evolved through the years, and it's becoming narrower and narrower with every judgment of the court. Under public policy, there are generally three heads: fundamental policy of Indian law, justice, morality, and a fourth head, which has only now been prescribed for domestic arbitral awards. This is called patent illegality. This ground of patent illegality can be applied only for Indian seated domestic arbitrations. However, this ground is not available for international commercial arbitration seated in India or for foreign arbitral awards. Now, the demarcation of this was done by the Supreme Court in a recent judgment called Sangyong, where the grounds were demarcated as to what is available to foreign arbitral awards and what is available to domestic awards. And this is important because there are very narrow grounds now which are available to foreign arbitral awards. Things such as non-consideration of evidence, perversity, or not dealing with particular evidence, all of this has been shifted to patent illegality. So at this point, all these grounds are not available for a foreign arbitral award. Courts at every level, including the Supreme Court, are viewing the three grounds: fundamental policy of Indian law, justice, and morality for foreign arbitral awards with a very narrow lens now. And in our experience, we have seen that it's very rare for arbitral awards to be refused, foreign arbitral awards to be refused enforcement day by day.
Sure. And with that, I think one other ground which typically we have seen when there is an appeal proceedings or setting aside proceedings pending in the foreign courts, and we saw that particularly in the Renbaxi case when Delhi High Court was considering a recognition of a Singapore award. In your experience, how does the court look at those pending proceedings when they are pending in the country where the award is passed, or the seat country, as we say?
Right. So the Indian Arbitration Act itself provides that when there is seat proceedings that are pending in the courts at the seat, then the Indian courts can adjourn the proceedings and, if necessary, also provide suitable security to the party. So here the word may has been used, so it is up to the Indian courts to decide whether to adjourn it or not. So generally, in our experience, I would say what we have seen is that it would depend on how the proceedings at the seat court are ongoing. So in the instance that the seat court has actually provided a stay on the arbitral award, then in such a case, it is possible that the Indian courts may choose to adjourn the proceedings, or a party may even press for dismissal of the proceedings until the award has been reinstated, if it does get reinstated. If
Sure.
no stay has been provided, then it's possible that the Indian courts may even proceed with the enforcement of an arbitral award, since it's completely within the Indian court's discretion as to how to deal with such enforcement proceedings.
Sure. I think I'm already seeing quite a few questions coming in. Like Abdullah was asking, what was the judgment of Delhi High Court? It was Kane India versus Government of India. In fact, I have sent him separately the link of the judgment as well. So that question, at least Abdullah, that possibly solves your issue. There are other questions also which will come very soon and address those questions from Harish and Deep. But before that, let me bring in Nick, because his time is very valuable. He's sitting in London and helping us around understanding this topic. So let me first bring in Nick here. And Nick, you have practiced international arbitration for maybe more than 2 decades. And your experience in India is also almost the same. We have seen you here in many arbitrations and arbitration related work. What's your perspective on India when it comes to enforcement of awards and judgments, both, not only awards? What has changed since you started the practice and looking at India?
Sure. Thanks, Vyapak. And thanks for hosting me on your webinar. It's a great idea to have these know-how events while we're all of us locked down, and I hope all the listeners are bearing up with that. So yes, look, I've had the great pleasure of dealing with an outsider's view of Indian arbitration for the last 15 or more years. And I had a little State of the Nation discussion back in 2016 on where we talked about the state of the arbitration environment in India and the increasing pro-arbitration stance in courts. I think from an outsider's perspective, looking at developments over time, that has been a thing. I think India has become increasingly pro-arbitration, both in terms of supporting arbitrators along and supporting enforcement. That has clearly been led from the top. When you think about the Supreme Court judgment in Balco, which did so much to clarify the distinction between the international regime and the domestic regime, and also some good and supportive judgment, in particular from Delhi and the Bombay High Courts over time. So I think, from my perspective, the arbitration landscape in India in 2020 has changed, I think improved from I guess from an outsider's perspective, we look back at things like the White Industries BIT decision. So that was, as listeners may recall, a bilateral investment treaty case that was decided in 2011, where an UNCITRAL tribunal seated in Singapore found that the delays in the enforcement of an arbitration award, which a Australian party had experienced in India, spent 9 years trying to get an ICC award enforced, in fact breached the bilateral investment treaty between India and Australia, and an obligation in particular to provide effective means of asserting claims and enforcing rights. And of course, at the time, that sent some fairly big ripples through the community, both in India and internationally, that decision was made based on effectively delays in the Indian court scene. And I think there was a reaction to that. There was a reaction both in terms of the attitude towards investment treaties, but also, I think, from the courts in terms of trying to move the timelines along. And I think that has been an important message from the courts and from the government. Of course, we know the Indian government is very keen to improve India's ranking in the ease of doing business surveys, and the ability to enforce contractual rights, enforce awards is critical to that. I also think, looking over time and the number of years we've spent discussing whether the Arbitration Act, Indian Arbitration Act, should be amended. And then, of course, we've had a flurry of amendments in 2015 and then in 2019. And that has shifted the discussion, I think. From a domestic perspective, the clarification that Section 34 doesn't apply to international awards was significant. And I think hugely significant was the amendment to Section 36 to remove the automatic stay, because I think that sends a powerful message about enforcement of awards domestically, of course, but also I think it's a message of intent about enforcement of international awards. So I think that has shifted the expectations and shifted the dialogue. We now talk about the timeline of the Act in terms of months, be it 12, 18, 24 months for the arbitration, and timelines in terms of months for enforcements and dealing with challenges. Whereas 10 years ago, we did talk in terms of years in this sort of sphere. So I think it's changed dramatically over time. And I'm pretty positive about the way it's developed and is continuing to develop.
Sure. And particularly, sitting in London and looking at the jurisprudence there, which I think India also, in a sense, gives due respect when they consider their law, and take a cue as to what is happening in your jurisdiction. How is the landscape of enforcement shaping up? Are we pretty much at par? Are we behind them? Do we need to take more, examples and more help from some of the jurisprudence that has developed in your jurisdiction?
Well, I think the framework is very familiar for Indian practitioners in terms of how we approach enforcement of arbitral awards in the UK, in English courts. UK is also a signatory to the New York Convention, along with India. There are 163 signatories now. Palau signed at the end of last month, so the body ever grows. And the English courts will look at those grounds for refusal to enforce an award under Article 5 of the New York Convention, typically a failure of the process, if the decision made is outside the agreement to arbitrate or the agreement was somehow invalid, if the award is not yet binding or has been set aside at the seat. As has already been mentioned, that might be a ground perhaps to refuse enforcement or perhaps to stay enforcement if there's a reasonable timeline when a challenge to an award in the seat will be dealt with. We also in the UK do have the grounds, of course, from the New York Convention that enforcement may be refused if it is contrary to public policy. I think the distinction between the UK and India is we don't see that ground being raised very much. We tend to see to awards are often around allegations of procedural unfairness, not being able to put all the arguments, the tribunal not having dealt with all the arguments perhaps in an award. We very rarely see challenges brought under public policy. The English court has defined public policy definitively, not have a definition in statute, but it's clear that the bar is very high and that for the English courts, public policy in this context means international public policy. So if, for example, you have an award which the tribunal has found is not illegal under the law that governs the contract, even if that might be illegal as a matter of English domestic law, courts will not treat that as offending public policy unless it rises to the level of engaging international public policy. And as I say, there's no definition of that, but I think you're talking about things like terrorism financing, money laundering, slavery, people trafficking, these very serious international issues. Otherwise, we don't really see public policy being argued a great deal. Arbitral awards are enforceable in the same manner as judgments or orders of the English court. We have that under our Arbitration Act. We do have provisions for challenges of awards. We see awards getting challenged on the grounds that the tribunal lacked substantive jurisdiction. That's under Section 67 of our Act. So under Section 68, on the ground of a serious procedural irregularity causing substantial injustice. And it's that Section 68 where we do see challenges to enforcement. It tends to be under Section 68, unless there's an easy jurisdictional point. Now, those challenges under Section 68, the court sets a very high hurdle for success. They are all heard in the commercial court in England and Wales. The commercial court publishes statistics on those challenges. We had some out in February 2020, which showed very few challenges being brought. So under Section 68, these procedural irregularity challenges, only 19 applications were brought in the previous court year, 2018-29. That was down from the year before, where there had been 71 applications brought, and incredibly difficult to get over that high hurdle. And also, the English court is very quick to award costs for a failure of such an application. So there's not only a high hurdle to success, there's a high cost of failure. And that explains, I think, why so few of these challenges are brought. Even when they're brought, they are mostly unsuccessful. The successful challenges tend to be single figures each year. A report of successful challenges from the court, 2017-18, there were no successful Section 68 challenges in that year. So all 71 applicants lost on their attempt to challenge the award with irregularity, and I would predict that most, not all of them, were then ordered to pay costs pretty soon after. And I think the timeline is relevant because although I wouldn't claim the English court is super fast, these things are dealt with relatively quickly. So I had a Section 68 challenge which was dealt with in a very typical time frame within 12 months. So we had an award at the end of 2018, challenge. We had a hearing in Q4 2019. The hearing was down. We argued for half a day. The judge gave an oral judgment straight after lunch. and dismissed the application and awarded costs. So you're dealing with a situation where a challenge under Section 68 is going to be dealt with in a year, it's going to be dealt with pretty quickly and robustly, and you are likely to end up wearing those costs if you don't succeed, and most people don't succeed. So it's a pretty robust framework, actually, which means that we don't see that many challenges.
Sure. So I will, obviously, you have experience not only for India and UK. I think you have practiced in Singapore and also have done a lot of work in Russia. We want to cover the whole world while you are here. But before that, maybe we can also answer some very basic questions which are coming on the chat window. Like Nancy was asking, what's the difference between foreign judgment and foreign award? I think that the basic difference is one is from a court or a foreign court, and second is from a foreign seated tribunal. There are other questions as well from RS and Harsh. I think, Moazzam, you want to touch upon them quickly, and then we go back to Nick on some of the other exciting jurisdictions like Singapore and Russia before we come back to India.
So I think one of the questions which came up was a very practical one, which is what is the applicable court fee in respect of a foreign award? So court fee typically varies, between 100 rupees to a couple of thousand rupees when it comes to enforcement of awards, be it foreign, domestic, and the same is the case for judgments as well. So, for example, in Delhi, it can be anywhere between 250 rupees to 2,000 rupees. And it will also depend on what kind of reliefs you're seeking in your enforcement application. So, for example, if you're seeking a relief of an injunction or some attachment, that additional court fee becomes payable, and it's usually very nominal.
Yeah, so it's basically very nominal. Yeah.
Yeah, it's got nothing to do with your underlying award. So, for example, in the UCOS versus Russian Federation enforcement, which was happening, which was a $50 billion award, the court fee which was paid for was, I think, 1,750 rupees. So you can imagine. I think one question which Dhananjay had is whether a foreign award could be objected to under Section 13 of CPC for not being conclusive. The short answer to that is no. Supreme Court has repeatedly held in a patina of judgments that the only mechanism to resist enforcement of a foreign award are those limited grounds which Bhavana alluded to earlier on, which are under Section 48 of the Arbitration and Conciliation Act. And I think there were a couple of other questions, but maybe when my turn comes to speak on some of the questions that Vyapak may have for me,
yeah, I think there are a couple of questions from Karthikeya and Harsh on the applicability of IBC and moratorium while an enforcement is filed, particularly for an execution. Maybe you can deal with it a little later. Before that, let me bring in Nick again. While you have very well apprised us for India and UK, you have also spent enough time in Singapore, and as we all of us know, Singapore is the best place to stay in India. We have so much happening so far as arbitration is concerned when Singapore jurisdiction is considered. Jurisprudence there is very important for us. So how does that fare vis-a-vis India? Do we say Singapore is also pro-enforcement jurisdiction? While in India as well, Nick, you may know, there is hardly any example of a foreign award which is not recognized in India. So our track record is as good as any other jurisdiction. It's just that unlike UK, possibly every judgment is or every award is challenged versus only few, and therefore the delays make it difficult rather than the final outcome. But what's your experience with Singapore?
Sure. Yes, and look, I also echo that point about the Indian record on enforcement. Of course, ultimately awards do get enforced in India. The problem has traditionally been one of delays. Now, then you contrast that with Singapore. As you say, I lived and worked there for 3 years, and I also sat and continue to sit as an arbitrator for SIAC and ICC. Singapore is a super efficient jurisdiction. It's certainly a pro-arbitration jurisdiction. Courts will strive to uphold agreements to arbitrate and awards, and the court and the Indian Law Ministry see that as being an important part of being a safe seat. which of course is what in Singapore has done such a good job selling itself as a safe regional seat, and picking up a lot of India dispute work as a result. So I think you can expect the Singapore courts to take a very robust view of enforcing arbitration awards, not dissimilar to the UK court in terms of the approach they'll take and the very high hurdle they will use for considering any challenges. So awards will be enforced, and I think in terms of timelines, they're a bit quicker than the UK courts. So again, decisions will get made fairly quickly. Costs will also be awarded against losing parties. So there's a big disincentive in Singapore against bringing bad challenges to awards. That said, it's not the sort of jurisdiction where awards will simply be rubber stamped. So if there are good grounds to challenge the jurisdiction tribunal that produced the award, then those arguments are heard by the Singapore courts. Likewise, if something has gone wrong with the procedure, then the Singapore court is willing to hear those challenges. There's a good example of that a couple of years ago in a case JVL Agro against Agritrade, where a tribunal had raised a point in oral argument which had not been addressed by the parties in their submissions. It had been briefly addressed by the respondent and not by the claimant. And then subsequently the tribunal made the decision dismissing the claim on the basis of that argument, which essentially it had come up with and not given the parties full opportunity to address it on. And the Singapore court accepted that challenge. It said there'd been a breach of rules of natural justice and that award should be set aside. So there's a reasoned consideration of these challenges, but like the UK, successful decisions to set aside awards in Singapore are very rare, and there is a high hurdle for success and a high cost of failure. Of course, in Singapore, it's a common seat of arbitration. It's not always the place you go to enforce. It's a small jurisdiction. There may be assets in Singapore. Perhaps there are assets to the promoter rather than of the company. And it's not so easy to pierce the veil. So Singapore is not necessarily the place you go to enforce, although it may be the place that you face a challenge to the award in the courts.
Sure. I think there is one question from Zil Shah. Are there any popular sits that are not reciprocating territories? I would say better it not be. There should not be any popular sit when it comes to India if they're not reciprocating, because they are worth a paper. But yeah, earlier even Hong Kong was not, and there were quite a few Hong Kong seated arbitrations, but Hong Kong was never declared as a reciprocal country or reciprocal jurisdiction along with China till 2012. So that is only one example that I can think of. But Nicholas, there is a specific question for you as to, is there a significant difference between our section 48 in terms of challenge of awards versus your section 68?
Well, I don't think so, because essentially both are based the New York Convention and the obligations of both the UK and India to uphold the New York Convention and to follow Article 5 of the New York Convention and to only allow awards not to be enforced on limited grounds. I think, as I said, I would draw between the UK and India is that whereas public policy is an accepted basis not to enforce an award under the New York Convention and therefore in both the UK and in India, in practice, we very rarely see that brought in the UK. I think the same is true of Singapore, whereas I think in practice it is quite commonly brought in India, public policy as a grounds to resist enforcement and challenge awards. And indeed, India is not unique in that respect. And you touched on Russia, and I'll talk more on that if you want. But again, in Russia, where the record of enforcement is somewhat patchy, policy is often used as a ground to resist enforcement.
Sure. Also, one very interesting question, particularly in reference to Russia. So maybe you can take that and also give your perspective on that jurisdiction compared to India. Is the whole right to set waiver of the right to set aside an award? Do you think that is gaining momentum, or that is not something which you are seeing internationally? And then maybe you can also touch upon your experience with Russia.
Sure. Well, look, The right to set aside an award, as long as these grounds are enshrined in the New York Convention, then convention courts have to take account of them. The concept of an arbitral award being a unique and independent creature is particularly prevalent in French jurisprudence and to an extent in Swiss jurisprudence. We haven't really seen that gaining ground internationally. It's a debate that continues. The classic example is where you have an award that's been set aside at its seat. Philosophically, will certain courts say, I will still enforce that award anyway because it has a life of its own? Or will most courts take the sort of view that I think the English and Indian courts would take, which is it depends on the circumstances, the basis on which it's been set aside in the seat and all the other circumstances. Back to Russia, I'll give you a quick snapshot of that. We see a lot of Russian dispute resolution coming to London, both to the English Commercial Court and to arbitration. Often enforcement will happen in London as well, because of course many Russian business individuals have assets in London, although once again one shouldn't assume that simply because the promoter or the ultimate beneficial owner of your counterparty has a house in London or Singapore, don't assume that's available for enforcement. In terms of Russia itself, it's a New York Convention country, but enforcement is a tricky prospect in Russia. There was a very helpful survey done a couple of years ago by the Russian Arbitration Association, which valiantly looked at 10 years of case law of enforcement in the Russian courts, some 470 odd publicly available decisions, looked at the most popular grounds or common grounds for opposing enforcement, number one of which was a violation of public policy. So there again, we see that being front and center of attempts to resist enforcement. The statistics in Russia were a little bit mixed, I would say. At a superficial level, they were heartening. The average time for enforcement in the Russian courts was 5 months. Well, that's good. And overall, the enforcement success in the decisions they looked at were 80s and 90%. So that's not bad, it would seem. But actually, the picture is rather more nuanced. And what you saw when you dug into the data was that the successful enforcement of awards was largely in the lower value trade disputes, especially regional trade involving Ukrainian, Belarusian parties, smaller domestic or regional arbitration institutions. And then as soon as you started looking at higher value awards involving cross-border trade from parties of it and international institutions, the enforcement success rate dropped. So whereas you might have been looking at over 80% enforcement around, if you looked at enforcement of ICC awards, for example, enforcement dropped to 60%. If you look at enforcement of LCIA awards, which is a very common forum, cross-border arbitration involving Russia, enforcement was as low as 47%. So over half of all LTIA cases which were attempted to be enforced in the Russian courts over this period did not succeed. And the public policy ground was successful in 39% of all cases in which it was invoked, which I think is quite a high percentage really for what is generally quite a speculative grounds to resist enforcement. And again, when you look at the high value complex cross-border awards that you try to enforce in Russia, your success rate drops based on. So if an award, the statistics show, is for less than €1 million, you have a 90% chance of enforcement. If it's between €10 million, that success rate drops to 77%. And if it's over €10 million, which is where the big value cross-border awards are, it's as low as 34% your enforcement prospects in the Russian courts. So it is patchy. There is support for arbitration from the Russian Supreme Court. There are good noises coming out. They're attempting to put some restrictions around the use of public policy as a ground to resist enforcement. But safe to say, Russia is not an easy jurisdiction to enforce in. So if you have a Russian counterparty, then do think about the security situation, where else they have assets, and the realistic prospect of enforcement within Russia if the time comes.
Sure. I think we have gone all the way from UK to Singapore to Russia, which is I think not easy these days in COVID times. Definitely not physically. But let's come back to India and maybe come to the man who executes. That's what Moazzam is known in NDA. He has done quite a few of enforcement and execution matters for us.
Executes awards.
I
Just,
know.
just
Sure. So, what's your practical experience so far as India is concerned? If you can give a little bit of advice to people here, and also if you can take up few questions which are already there on the chat window, and then maybe I'll queue up the remaining as we go along.
Sure. So I think my personal experience, like Bhavana and Shweta was saying, has been completely lopsided, and that is lopsided in favor of enforcement of foreign awards. Now, foreign awards are treated as a very, very different animal in India. Like Nick was saying, that we're looking at probably a 99 point some percentage rate of enforcement. And this is regardless of, this is not a situation like Russia where, big money awards are not getting enforced, but smaller numbers are getting enforced. In India, everything is getting enforced. The only problem is the time, and you need a little bit of a innovative advocacy to get that time period to reduce. I think you also need, so we always keep talking about, whether courts are helping us, whether courts are assisting in doing this, doing that. I think the question to ask before we get to whether courts are assisting us is whether we are assisting courts enough. And that is an area which a lot of time is lacking in enough attention being given to it, and which is the reason why a lot of these enforcement matters actually suffer delays. One of the questions that one of our participants, Harsh, had put in is, what are your views regarding a client where a remedy for a client where enforcement of a foreign award is being delayed by the other party seeking unnecessary adjournment? Now, typically in more, in jurisdictions like Delhi, Bombay, Bangalore, Madras, you're not going to get adjournment. So unless you have a counsel who's agreeing to the other side getting adjournment, typically adjournments aren't given. Maybe one, maybe twice, if the other side gets a big shot heavyweight who puts in some personal difficulty argument in, and they get out. Unless, otherwise, if you're not agreeing to it, courts are not going to indulge in repeated adjournments in cases of foreign award enforcement. The other question is, what happens if a party goes bankrupt? Well, the simple answer to that is, did you do your homework before you filed the execution petition? Did you research on what is the financial soundness of the person against whom you're going to be executing an award? Reason is this: you don't want to be filing litigation in India for enforcement of awards and fight that, win that in a year's time or a year and a half or 2 years' time, and after 2 years realize that the other party has no money. So you need to do that homework before you get into the enforcement stage. And that's why I say whether we are assisting courts enough, whether we are doing that homework, making sure that the party against whom we're enforcing has the assets. I think Karthikeya also had a similar question, which is on IBC and whether there's a moratorium. So the moment a moratorium kicks in from an IBC perspective, all legal proceedings come to a standstill. So enforcement of arbitral award cannot proceed. So, goes back to my first point, which is, if you have a company which is not financially sound, whether it really makes sense for you to be fighting that enforcement battle in the first place. And I think so. Broadly, that is the flavor that we need to be assisting courts first, and then ask for courts assistance. There were other questions like Gautam and I believe Nancy had more or less a similar question, which is what happens to awards coming out on tax issues such as Vodafone, etc. Now, investment treaty arbitrations are a different animal. Awards coming out of investment treaty arbitrations are also treated as a different animal within India. right now there is no judgment to even suggest that a treaty award can be enforced in India, because it will not be treated as an international as an award arising out of an international commercial arbitration. There are multiple, reasons for that. India is not a party to the Exit Convention. We don't have a specific legislation dealing with treaty award enforcement. Delhi High Court has taken a view that treaty arbitrations are not covered under Part 2 of the Indian Arbitration Act. So, whether or not treaty awards can be enforced through the Part 2 channel is still up for debate. My personal view is no. And I've written a couple of pieces on that. You can, search online for them. I think
Sure.
I may have addressed more or less
Sure.
all the questions.
Sure, Moazzam. Let me come back to you. I have few questions for you. Before that, let me bring in Shweta, because there are questions on difference between what are the grounds for foreign judgments versus foreign awards as well. Shweta, if you want to, give a little quickly as to the requirements for enforcement of a foreign judgment, which is from a foreign court versus a foreign award, particularly the issues of, including the issues of reciprocating countries and the mandatory requirements as part of the enforcement process.
Yeah. Thanks, Vyapak. In case of foreign judgments, the regime is governed under the Civil Procedure Code of India. The first important thing which you have to consider if you have a judgment in your favor from a foreign country is whether the country is a reciprocating country or not. Now, unlike in case of foreign awards, very few countries have been notified as reciprocating territories here. Of course, the important ones like UK and Singapore have been notified. Recent addition to this list is UAE, which happened in January 2020. So the first important point is whether it's a reciprocating country or not. The story doesn't end there. You also have to see if the foreign court is notified by the Indian government as a superior court or not. Like, for example, the High Court of Singapore is a superior court, but the state courts of Singapore would not be. So only a judgment from the High Court of Singapore would be executable in India directly. Otherwise, again, you have to file a fresh suit and a separate procedure has to be applied over there. So over there, again, two important factors come into picture. The next important point that we have here is whether the execution petition which you are filing in India from the foreign judgment is within the limitation period or not. Now, Bhavana has already touched on this issue briefly. In case of foreign judgments, the limitation period which is applicable in the foreign country would be applicable in India. Now, for example, the limitation period for execution of decrees in England is 6 years. So if you have to file an execution petition in India, you have to file it within those 6 years. And in case you have taken certain steps towards execution in UK within those 6 years, then the date on which it's determined by the UK court that, the judgment is not yet satisfied and the proceedings are finalized here, then you can file the subsequent execution petition in India within 3 years from the date of finalization in UK. So basically the limitation law applicable in UK or the foreign jurisdiction would be applicable in India. The next important factor which we require to keep in mind is the certificate of satisfaction, certified copy of the judgment. These are certain procedural requirements. Though courts have been very liberal as to whether you need them at the stage of filing or subsequently, even then it's better to have these documents in place to prevent further delay tactics, etc. of the other party. Now, the broad grounds which come up for objecting to execution of a foreign judgment are under Section 13 of CPC. Some of our attendees have raised questions. So only under Section 13, whatever grounds are there, those are the grounds on which you can actually object to the conclusivity of a foreign judgment. The most common ones being the foreign court lacked jurisdiction, the judgment was not on merits, etc. Now, like foreign awards and domestic awards, Indian courts have been very pro-execution in case of foreign judgments as well. However, the foreign courts have to satisfy the basic needs. Ex parte orders are executable. However, default judgments are not. Say, for example, if the due procedure has been followed in the foreign court, there'll be very limited scope in India to enter into the merits of the judgment and set it aside over here. So, Yeah, Vyapak, I think I'm good
Sure.
unless you have further
Sure.
questions on this.
No, I have a couple of them. I'll come back to you. But before that, let me get one or two very short questions answered as well. So, Bhavna, I think Deep has, I think, a follow-up question on your explanation to the limitation as far as foreign award is concerned. And then there is Rahul Verma's question on whether patent illegality is a ground to challenge an international commercial arbitration seated in India, if you want to deal with it very quickly.
I think,
Bhavna? Yeah.
am I audible?
Yeah, go ahead.
Okay. On the ground, on the question on limitation, the question was whether the arbitral awards, the limitation period for enforcing foreign arbitral awards can also be considered as the country where the award was issued. So, as of now, this angle has not been considered by the courts. But considering that there is such an angle that the Supreme Court brought in through that Bank of Baroda decision, there is some scope for instance, if the Delhi High Court judgment may go into appeal, for the courts to make a different finding. But as of today, the limitation, as I said, there are divergent views of courts. So it's some courts have considered to be 12 years, some considered to be 3 years. So to be cautious, we'd say that file an enforcement petition within 3 years.
Yeah. Also on the patent illegality, if you want to touch.
Right, sorry. Vyapak. So on patent illegality, the 2015 amendment has brought in the patent illegality ground only for domestic seated arbitrations and not for international commercial arbitrations. So under the Arbitration Act, international commercial arbitration is defined as on the basis of the domicile of the party. So if there's a foreign party and you have an arbitration seated in India, that is an international commercial arbitration, and patent illegality would not apply as a ground for setting aside such an award.
Sure.
Only for
Nick, there is also one very interesting question for you. If you are still around, I'll ask you. How have the UK courts dealt with enforcement of awards post ECMIA and Brexit in claims arising out of inter-EU DITs? This is from Anurag. Are you there?
Well,
Yeah.
I am here. It's a good question, but it's slightly premature. The English courts haven't yet weighed in on the decision, which was, of course, 2018. So it's still early days. A few courts, Swedish and German, have had to deal with questions under ACME. The English courts haven't yet. So we'll wait to see what they say about it. Of course, by the time they do, we may well not be in the EU again, which comes to the second point on Brexit. Of course, contrary to all the sound and fury, Brexit has not really yet happened, in that the UK is still in a transition period with the EU until the end of this year, subject to an extension. The absence of negotiations that have been happening in the last couple of months. So we haven't had to deal with that yet either. Brexit impact on enforcement of court judgments intra EU. It won't have an impact on arbitration because the New York Convention will continue to apply. Intra-EU court judgments, which are currently dealt with under the Brussels regulation, will cease to be dealt with under that because the UK won't be a party to that regulation, it being an EU instrument. The UK intends to become a party in so probably won't really notice difference there, and in any event it's only intra-EU. Yeah, we wait and
I think there is one more question related to Delhi International Arbitration Center and whether that will change the status quo with respect to enforcement. I think the short answer to that, to Akshat, is that's in a way a step towards institutionalizing arbitrations in India, which only means along with the other institutions like the DIAC, the NPAC, the MCIA, and others, the quality of awards will only get better, and chances of challenges and setting asides will only get lower. So I think, yes, the more the institutional arbitration, it will only help. but per se, because it is institutional arbitral award, does not change the process of enforcement. But I'm sure the quality of awards will have a big impact on how the enforcement proceedings or challenge proceedings are governed or are disposed of by the courts. So I think that is definitely helpful. Moazzam, we are very close to ending the session. We just have 2 minutes, but maybe one last 1 minute final comment from you, and then we'll end with Nick, considering he's our chief speaker today.
Yeah, I think in a minute, if I have to sum up the execution process of courts in India, I think a lot of parties have this concern that execution is like you're virtually fighting a suit all over again. That's not the case. That's not how it happens. Execution, actually, once you get through the recognition for a foreign award, that's going to be your toughest stage recognition. And that's why you face the most number of delays because of all the challenges and adjournments which other attendees are pointing out. But the moment you cross the recognition stage for a foreign award, and you don't even have that stage for a domestic award, if once the challenge proceedings have been set aside, and you get into actual execution, from day one you start getting relief. From the first day. From the first day, the order which is passed is attachment of assets. From the first day, the order which is passed is discovery of
Moazzam,
bank accounts.
your voice. Sorry, Moazzam, to interrupt. Your voice is cracking a lot. So I'll just summarize in a second what you wanted to say, which was, I think, stories of execution in India are not bad. You start getting reliefs on day one if you are strategic enough and you have good lawyers like Moazzam. So that's not a problem. So maybe if Nick, you have any last comment, and then Nishith bhai, you are already there on this session. If you want to thank the participants and particularly Nick.
Thank you, and let me first of all say thank you for inviting me on this session, and wish everyone well in these difficult times. In terms of enforcement, I would really just echo the point that Moazzam made earlier, which is the most important point about enforcement is not to think about it only when you get your award or judgment. You have to have thought about it before then, before you spend the effort in getting that award. The atmosphere for enforcement, as I say, I think India is moving in a great direction. It's true that the more ready courts are to enforce awards, the less they are asked to do so. Because if responding to a view that resisting enforcement is going to be a short, painful and expensive process, then the less they will actually do it. So I think it's a virtuous circle once a jurisdiction starts to become pro-enforcement.
Yeah, thanks a lot, Nick, for your very, very valuable inputs and taking us through all the jurisdictions. Nishith bhai, your final comments?
Yeah, my comment is only for Nick. I think, Nick, thank you so much for joining us this afternoon. I was on the session throughout, right from the beginning. So it was wonderful to hear your views and ideas and, experiences. So thank you very much. We really appreciate you finding time to join us, and hope we can continue doing more and more interesting things. It's always been a pleasure to be working with you, and I just want to thank Vyapak and Moazzam and Bhavana and everybody else on the panel, and also our audience, which is there in large numbers, and really, thanks each one of you. Greatly appreciate your interaction, and this will, I'm sure, be very useful, and not only for this session, but also the recordings will be very useful to many other people. So once again, thanks, Nick, and thanks everybody.